Jackie is with CELA, the Canadian Environmental Law Association, and Jackie today will talk to us about the work that CELA and the Low Income Energy Network have done over the past 2 or 3 years on maximum heat bylaws. Take it away, Jackie. Thank you.
Thank you, Abby. Is my screen sharing well? Can everyone see my presentation?
Yes.
Perfect. Okay, thank you very much. I'm Jackie. I'm a lawyer at the Canadian Environmental Law Association. So Z has introduced CELA. We're one of the legal aid clinics that co-runs LEAN, and our mandate is focused on environmental equity, justice, and health. We also have a charitable arm, which is the Canadian Environmental Law Foundation, and that's focused more on education and archiving environmental law history. To kick off my presentation, I wanted to try to offer a definition or a starting point for a definition of environmental racism and environmental justice. They're very difficult concepts to define, but what these definitions that I've put in my presentation are trying to capture is a few different pieces: the higher burden of environmental harm on Indigenous and racialized communities in Canada, and also on the flip side, uneven access to environmental benefits, to programs that are designed to assist with environmental, like heat pump programs, so environmental benefits. Fair treatment is a key aspect of the definition of environmental justice, and it requires meaningful involvement of all communities and people in environmental decision making, again, in terms of the burdens of pollution and environment on different communities, and decision making about environmental benefits and programs. Environmental injustice in our communities takes several different forms. I've listed some. So for instance, polluting industry being located disproportionately close to under-resourced communities, less access to meaningful public participation, for instance, because of unreasonable burdens on under-resourced communities. So there's too many consultations. They don't have resources. There's not money to participate. People aren't being compensated for their time. All of those burdens are part of environmental injustice. There's lower levels of enforcement in under-resourced communities. And interestingly, one I wanted to highlight, which I think is important, and what Abby was getting at in his introduction, what I put on the slide is increased pressure or rhetoric about accepting conditions that wouldn't be accepted in other communities. So what I put on the slide was, for instance, about accepting polluting industries near those communities. But in terms of the right and the discussion that we're having today about access to heat, under-resourced communities are expected, or they're spoken of, about enduring conditions that the rest of us don't subject ourselves to and don't think we need to. So there's no limitations, for instance, on active cooling if you can afford it in our community. Climate change is a very serious environmental justice issue. And I like to say that in terms of thinking about the crisis, it's important to think about it as an environmental crisis, a public health crisis, and an equity crisis at the same time. The IPCC has long recognized different dimensions of equity in talking about climate change. One of the ways that they talk about it that I think is quite interesting is they talk about pillars of equity. They talk about equity between countries and between generations, so intergenerational equity. And then the third pillar, which is kind of most key to our discussion today, is between people within communities based on environmental justice considerations like indigeneity and racialized communities, but also on income levels as well. In its recent 2023 synthesis report, we were really pleased to see this focus on equity and talking about how to move on mitigation and adaptation measures that we so desperately need to deal with the climate crisis. And finally, I did want to point out that our Supreme Court recently, in the carbon pricing decision, also highlighted the disproportionate burden of the climate crisis on low-income communities. I highlighted paragraph 206 of that decision, which notes the irreversible harms to the environment that would be borne disproportionately by vulnerable communities and regions. And they highlight in this paragraph Indigenous people the people living in the Canadian Arctic and northern regions and Canada's coastal regions. Um, I think, as we all know, extreme heat is a really serious health concern, and it can cause very disproportionate impacts on particular groups. So, seniors, infants, and children, people suffering from certain chronic illnesses or taking certain medications can affect your body's ability to recognize the impacts of heat, and people with social disadvantage. And as Abby mentioned, what's really striking about the reports that came out of Quebec's 2018 heat event and British Columbia's 2021 heat event is, first of all, how similar they were to each other in terms of who was impacted, but also the fact that it really is about people dying in their homes, in the units where they live. And so, in our view, in Lean's view, we need a solution that addresses that head on. How do we make the units, the places where people are living, livable and safe? So moving on to the law reform project that CELA has going on, it's focused on climate change in vulnerable communities. And we've written a series of reports that looks at different legal options and tools available to try to assist with adaptation measures to deal with some of the worst impacts of climate on vulnerable communities. And so there's a bunch about flooding and green roofs and urban tree cover that I highly recommend to all of you, of course. But the focus today will be on maximum temperature bylaws. One of the key focuses of this project has been on collaboration at the local level with other groups working on climate justice issues and other legal aid clinics. And for the most part, we've been focusing on municipal power to act on climate, with the recognition that this is definitely an all hands on deck situation. All levels of government need to be doing the utmost within their jurisdiction to be assisting with the climate crisis. But there is momentum and interest at the municipal level, which we think is a good opportunity for a focus for advocacy. That being said, the first point I just wanted to make quickly is, in terms of Ontario, we don't have good data that tracks heat related death. And so this is a provincial piece to this. Currently, the Ontario Coroner's Office doesn't accurately track and doesn't capture heat related death unless it's a very kind of sort of very obvious heat related death, for instance, a child being left in a car and that kind of thing. So those types of death may be captured, but when it's a contributory cause or a secondary cause of death, it's not currently being captured by the way that we track heat-related death in Ontario. And interestingly, the coroner's office acknowledges, first of all, that the way it's tracking death isn't capturing the scope of the problem and that it's a serious health issue. In our view, this is a problem because data, first of all, is important. It helps to define the scope of the problem accurately, so you know what you're dealing with, where you're dealing with it, who's dying exactly, and why. And it also allows you to track whether the policy responses that you're putting in place are working, whether you're making progress, whether you're helping. Other Canadian jurisdictions are better dealing with the problem, and I'll just briefly mention two. British Columbia, during the 2021 heat event, the coroner sent out a reminder. So, it wasn't a new policy, but a reminder about coding deaths based on them being accidental and not natural. And in Quebec, there's a system that kicks in during extreme heat events where medical practitioners will fill out surveys to try to get data about the deaths. So if there's a concern that it's heat related, they fill out forms that talk about whether the person had air conditioning, the temperature of the home if the person was found at home, what neighborhood they're in, what kind of house it is, that type of thing. And along with death related data, I would just throw out there that I think we need to be considering different ways of tracking other pieces of the health puzzle here. So, heat related illness, emergency room visits, doctor's visits, that type of thing. I wanted to highlight for people in the conference that we have done a legal memorandum that looks at the broad scope of municipal power to act on climate change. The leading case on this issue is a 2001 Supreme Court of Canada decision. It's old, but it's still the leading case, and it's called Spraytech and Hudson. And it upheld a cosmetic pesticides ban by focusing, first of all, on the broad municipal powers to deal with environmental issues. The fact that municipalities can enhance protections provided by other levels of government. And the focus is really on operational conflicts so that there can't be direct conflicts and an inability to comply with laws at different levels of government, but otherwise you can enhance protection at the municipal level. And the Municipal Act in Ontario further helps with this type of broad understanding of municipal powers. And I threw on the slide, there's a few sections that are of key importance. So Section 8.1 states that the powers of municipality are to be interpreted broadly. And Section 10.2 and Section 11.2 provide for municipal powers to pass bylaws, including respecting climate change and environmental well-being in the municipality. Okay, the final thing before I pass it off to others who will talk more about adequate temperature bylaws is we did want to highlight that we've provided draft language in our report available on the CELA website because we think it helps, first of all, as a starting point. So what I've put on this first slide is a few of the definitions that we included in the draft municipal bylaw to set an adequate temperature. So the first thing is that we set a maximum temperature of 26 degrees. And the reason we did that is that we looked at the literature on the issue. There's been a lot of work already done on this issue. And 26 has been a temperature that's been kind of coalesced around in the literature. So there's lots of data on that. It's detailed in more with some detail and some references in our report. But we did choose that based on what we saw in the literature. And then there's some other definitions, dwelling unit. And then on the next slide, we've got landlord and tenant. And we're just taking those definitions from Ontario's Residential Tenancies Act. In terms of what the draft bylaw says, this is sort of the critical piece. And what it says, first of all, is that adequate and suitable cooling is to a maximum 26 degrees. And how you measure that. And the way that we framed this definition is by looking at what's done for minimum temperatures, because we see cooling based on the climate crisis, based on the health issues that arise, as simply the other side of the coin of minimum temperature requirements for tenants. And finally, the language that we've included, which we're certainly interested in thoughts on and debate, but we focus first of all on, in subsection 3, I'm going to jump down for a second, on ensuring that there's infrastructure in place. So that's kind of the crux of this, that there has to be the infrastructure in place so that different units can be cooled to a maximum of 26 degrees. Our subsection 2 notes that if tenants already are able to do that, then this doesn't apply. So that means that the infrastructure is already in place in those units. And then subsection 4 is trying to get at the idea of there being kind of like appropriate standardized equipment, so that that the equipment being used to meet these requirements are safe and standard. And then finally, we have proposed a 1-year implementation period. Okay, I'm going to leave it there and turn it back to Abby. Thank you so much.